Thank you. The Bar Human Rights Committee has a number of aims, but relevant to today are our aims to uphold the rule of law and internationally recognised human rights standards, and to support and protect practicing lawyers and judges and human rights defenders who are threatened or oppressed in their work. Given those are two of our aims, it's not surprising that Turkey has been one of our main concerns, countries where we've had a lot of concerns in the last couple of years. Very concerned about lawyers and judges losing their positions, losing their jobs, having to leave the country and facing trial and detention in Turkey itself. With other groups and lawyers, we've been involved in trial observations over the last 2 years of lawyers and others who've had alleged links with the coup attempt in 2016. We've been concerned about the rule of law, the right to a fair trial, and freedom from detention and unjust conviction and sentence. We've produced reports each time we've gone to Turkey and observed trials. You can find those on our website. They're quite detailed reports which go into a lot of the background of the international law as well, on which our conclusions are reached. The most recent one is from a trial from a couple of weeks ago, and that's going to be going up on our website later this week. That was a trial of journalists and lawyers involved in the Zaman magazine. I've got time today just to give you a couple of bullet points descriptions of what our findings so far have been. First of all, we're alarmed at the role of judges in the trials. Often trials are adjourned a number of times after a few days' hearings, only to be resumed after that period of time in front of a wholly differently constituted court. So completely different judges hearing the same case on different occasions. Very hard to see how justice can be done in those circumstances. The judges themselves, our observations indicate, seem uninterested in the weakness of cases which are brought against defendants, uninterested in granting bail to them, and also seem to have a very close relationship with the prosecution. All of those are concerns that we have about the independence of the trials. The indictments and charges that people are facing are often completely unspecific about the individual offences that defendants are alleged to have committed. Often indictments are several hundred pages long, which include a long background to the coup attempt, what happened afterwards, the implications, but will often only have a sentence or two about what a particular defendant is alleged to have done, alleged to have been involved in. And often those couple of sentences will be used to base allegations that the defendant has attempted to overthrow the government of Turkey. So it's very hard for people to understand what offences they're alleged to have committed. And there's a complete lack of disclosure in many cases of information to defendants in these trials to support those charges. So not only is it vague, the charge itself, but the documentation to support that charge is wanting too. Often witnesses who are due to attend trials to back up the prosecution of the case don't attend, and that doesn't seem to bother the court either. Defendants have also claimed about late disclosure of documents in trials as well. So a trial can carry on for weeks and not months, and it's only at the very end of the trial that the prosecution will disclose important documentation to explain the basis of the charge. And we find that there's insufficient evidence in many cases to disclose to establish even a prima facie case, which could warrant continued detention and prosecution. So our findings of these cases brought against defendants are very weak indeed in many respects. Also, we're concerned about lack of access to defence lawyers for defendants who are being held in detention. Often we're told that defendants only have access to their lawyers in an offence, in a trial which may lead to them going to prison for a very long time, often for only a week or so. Only for an hour a week at most. And also there's a detention in prison at the moment, pending trial of 500 lawyers at the moment. And many of those detentions, we say, are not justified. There's now very long sentences being awarded against defendants in these trials. Our observers in these cases have been very experienced criminal barristers from the UK, steeped in years of experience of conducting and being involved in criminal trials. And their conclusion about these trials is that they have all the appearance of show trials. There's no real attempt to properly prove allegations against defendants, and the trials are aimed at simply achieving convictions. So in the face of this, what BAHRI Human Rights Committee has urged Turkey to do is there's a list of 4 or 5 things. First of all, to honour constitutional and international commitments to the rule of law and fundamental rights and protections. First of all, secondly, to bring the state of emergency to an end as soon as possible. Thirdly, to introduce measures to reinstate the independence of the judiciary and the prosecution. Fourthly, to release all those detained in the aftermath of the coup attempt and discontinue charges unless there's clear and substantial evidence of crime. And lastly, to implement more widespread granting of bail pending trial in cases where it's appropriate for those trials to continue. And in our view, that's the least which is required to start to bring to an end what can only be described as a gross violation of the rule of the law in Turkey at the moment. Thank you.